All right, what question you guys doing?
5.1.
Did you play?
Yeah. All right, Unit 5, Question 1. Why have First Amendment rights been viewed as essential to the functioning of a free society? In what ways have these rights been of particular importance to women and minorities? Although First Amendment rights are considered essential to a constitutional democracy, it is sometimes argued that these rights must be limited. Under what circumstances, if any, do you think limitations are justified? Explain your answer. You may begin when you are ready.
Economist Frederick August Hayek wrote in his book, The Constitution of Liberty, "What a free society offers to the individual is much more than what he would be able to do if only he were free. A society gives citizens the opportunity to choose and act on what one believes, as long as it doesn't harm the freedoms of the common good. Americans are free, but it's the components of a free society, like the First Amendment, that provide us with a chance to prosper."
When establishing First Amendment rights protecting freedom of religion, the framers reflected upon their knowledge of history. The founding generation viewed the damage that religious intolerance caused through the Spanish Inquisition and religious wars in Europe, and realized the importance of the individual practice of religion. The framers believed a society cannot be considered free unless it offers the choice of religion.
The First Amendment also states that Congress shall make no law abridging the freedom of speech or of the press. In the words of Thomas Jefferson, all tyranny needs to gain a foothold is for people of good conscience to remain silent. The framers knew that the people of good conscience needed to have the rights and abilities to speak, publish, and express their grievances freely in order to provide a check on the government. John Locke's idea of a social contract between the people and their government heavily influenced the founders.
According to John Locke, free speech and press are essential, as the will of the people must be known if they are to be sovereign. The founding generation emphasized these rights in order to avoid situations like that in modern Pakistan. In October, 14-year-old Malala Yousafzai was shot by the Taliban while returning home from school for her work promoting female education. These nations, plagued by fear, reinforce how crucial the rights of the First Amendment are to a functioning free society.
The rights stated in the First Amendment are not only essential to a free society, but also to an evolving one. Many minority and feminist groups have utilized the rights given to them by the First Amendment. The women's suffrage movement progressed thanks to freedom of press and the right to petition and peacefully assemble. Suffragettes used the Woman Voter magazine to spread their cause and the right to assemble by holding marches, such as their 225-mile hike from Newark, New Jersey to Washington, D.C.
The Establishment and Free Exercise Clause, along with the right to petition and assemble, formed the backbone of the civil rights movement of the 1950s and 1960s as well. The freedom to practice their religion freely was one of the few rights that was not denied to African Americans by segregation. This made it possible for the children to gather en masse at the 16th Street Baptist Church in Birmingham to begin their famous children's crusade that eventually led to the desegregation of Birmingham. However, there are instances where limitations are necessary.
Although the First Amendment was meant to protect citizens from the interference of the government, Citizens United v. FEC gave corporations protection under the First Amendment as well. It allowed corporations to give unlimited amounts of money to the political arena and establish super PACs. Corporations should not be protected under the First Amendment, particularly with money qualifying as free speech.
First Amendment rights can be denied to citizens under justifiable terms. Some of these restrictions are known as time, place, and manner regulations and have been outlined through a series of Supreme Court cases.
Frisbee v. Schultz upheld the law that banned picketing in front of residential homes. The majority opinion read that the regulations of time, place, and manner of expression, which are content neutral, are narrowly tailored to serve a significant governmental interest and leave open ample alternative channels of communication. Thus, the regulations are justified because they ensure that a person's security is not put in jeopardy.
The First Amendment embodies the values of American society holds closest, and women and minorities owe their progress in part to these freedoms. Since its inception, a balance has been maintained between this liberty and the restrictions respecting the personal security of the nation. Thank you.
Time? I didn't take time. I was by myself, I had a lot of responsibilities.
You did very well by yourself.
So, many have argued that religion has gotten a bad rap in the courts. Do you agree or disagree with this opinion?
I I do not agree with this opinion. Religion has been given the same opportunities in the courts as people and organizations. In the court case of Vaughn, it's Vaughn something v. Perry, there was a statue of the Ten Commandments put up next to a Capitol building, and religion was given, or the people who built the statue were given free rein to put the statue next to the Capitol building. So religion is not thought of as a bad thing in the courts.
I think the courts have helped religion in a way that they've tried to keep the separation between church and state, and that's not, the reason they do that is for the integrity of religion and to keep that pure and to keep the values uncorrupted. An example of that is the Lemon v. Kurtzman, which established the Lemon test, which kind of gave guidelines for establishing if something violated the Establishment Clause. That was to keep religion and state untangled. So.
Also in Agostini v. Felton, it was a case about New York had passed a law that public school teachers could not teach in private school, particularly like Christian schools, because they thought that would violate the Establishment Clause. But in this case, the Supreme Court ruled that it didn't, and that the interference between religion and state doesn't always mean have always like a positive or a negative effect. Sometimes it's kind of neutral. So I feel like that was a case where the Supreme Court supported religions.
What are some limits on assembly?
Like we mentioned in our testimony, there is the time, place, and manner, which means that people can only assemble at a certain time, and they have these restrictions so that it protects people's security and privacy.
For example, in the Supreme Court case of Cox v. New Hampshire, Jehovah's Witnesses were gathering in mass, and the court convicted them because they were not given, the state of New Hampshire was not given enough time to provide proper policing to ensure that all citizens were kept safe.
What about the case of Westboro Baptist Church?
Next question.
You have no idea what it was.
Oh, you know what it is.
All right, what is the relationship, if any, between the Sixth Amendment's requirements of the right to a speedy and public trial and limited government?
Well, the right to a speedy trial, and a trial in that case too, limits government because it makes it so that people have to have a trial, which is a form of limiting government, and because it means that the government can't just stick people that speak out against it into jail and silence all voices against it.
And during colonial times, when Britain still had rule over the 13 colonies, merchants who smuggled in sugar or goods under the Sugar Act were tried in England, making their trial not speedy and not fair at all. So that government had almost no limitations, and now with this speedy trial, there's a limitation on government.
Do we got some time, or we? Okay, we can shoot.
Does the wording of the First Amendment suggest a hostility towards religion, do you think?
I think by the First Amendment ensures that the religion doesn't entangle with state. The church and state are kept separate, and I think for that reason, that's helping religion and not showing hostility.
That the history has shown that through religion and state intermingling, that conflict has usually arisen through inquisitions and wars, and so the founding fathers knew that they wanted to keep these separate to prevent any kind of conflict between different religions or even those who believe in no religion, to create no conflict between them.
Where do you think the founders got the idea for the First Amendment rights? What kind of things in background or philosophers did they look at that have gotten the basis for the First Amendment?
They looked at natural rights philosophers such as John Locke, who laid out a couple fundamental rights that people should have.
Also, European history probably gave them a big idea because the Roman Catholic Church was established in the governments of a lot of countries, and that provided a lot of corruption and hostility towards people. They also probably looked to their own colonial history because the states or the colonies were a refuge for the Puritans, but then the Puritans themselves weren't very tolerant of other religions, and so that provided a lot of hostility for people in the United States.
Good words out there. Feedback.
I think you did earlier in the cross-sects a little bit better. I like when you say, for example, that really makes sure the judge knows the specific examples. Sarah